All rise.
Yes, Mr. Old.
Well, the court asked a point about the administration earlier. I understand that it was a pre-pack, and we plead that in 16.2.3 of the amended.
Yeah, you get that from the chronology.
And
The
yes,
sale was the day after the company went into administration.
and it started on the 24th of April 2017, and was closed on the 5th of March 2019, and then the company was dissolved on the 5th of June 2019. So to the extent relevant, those are the dates.
I mean, it really doesn't matter, but you don't know the actual date on which the administrators were appointed.
No, I think it's the 24th of April 2017.
Yes, I see.
Right, we got to 87, paragraph 87 of the judge's judgment.
Yes. And the judge's conclusion in paragraph 88 is applying his 6-point test, which we saw earlier.
Yes.
He says the losses are entirely derived from the claimed losses of the company. The claimants have a direct claim, but only have an indirect loss. And your Lordship has our submissions about that. The judge has not, anywhere in the judgment, in our submission, properly characterised the prudential rule as we've seen it. And hasn't simply not dealt with the knock-on point, that it's only where the loss is a knock-on consequence of the loss to the company that the rule has any application. But, my Lord, I'm conscious that I'm, in a sense, repeating myself, making the same point. So he then deals with the timing issue, which, as the court knows, gave rise to quite an interesting point because of the decision of Lord Justice Flo.
Yes.
And its inconsistency at that point with the Primeo decision, but it's been resolved by the Court of Appeal in the Allianz case. So nothing now turns on that. And he then goes in 114 and 115 to deal with
This is the clause 12 point now.
the clause 12.
Yeah.
Yes. Now, my Lord, I mean, I've shown the court the clause. We've looked at it in detail. The three key points about this are first that the relevant wrong is committed against the claimants and the loss is suffered by the claimants. That's beyond argument. Secondly,
So what's the wrong committed against the claimants?
they've been deprived, and that's the second point, of their contractual rights.
They don't have a contractual right unless the options are exercised.
Well,
What's the wrong that's been committed to them?
well, my Lord, the wrong is that as a result of the, well, stepping back, my Lord, the wrong is the breach of contract by the AA in all the respects that we've set out.
It's the same breaches of contract as in the original contract claim.
That's right, yes, it's the breach of good faith. But the consequence of those breaches in this instance is not a diminution in share value, but being deprived of the contractual entitlement under clause 12, as we saw before.
So is this right, that by committing the breaches of the agreement, the AA has caused the claimants two separate losses? One is the diminution in their in the value of the shares they hold, and the other is the potential to receive what I might call an enhanced price for those shares through the working out of the option consideration and the earn-out.
Under clause 12, yes.
Under clause 12, yes. Is that how you put it?
Yes.
So same breaches, but two different losses.
Yes, and they're in the alternative. We pleaded them in the alternative. Right. So this is a separate claim to the loss of share value claim, an alternative claim. The second point is that it's only the claimants who have a cause of action in respect of this, and not the company.
Well,
and as I say,
no, I don't think that's right. The company has the same cause of action, namely breach of the contract, does it not?
Well,
it has a different loss, you say.
May do, but a different loss, yes. It may have a similar claim, yes. And the form of the loss is being deprived of this loss is being deprived of the contractual entitlement under clause 12. It's not diminution in value of shares. And I won't take the call back to the main authorities, but we looked at paragraph 79, my Lord, in Lord Reed's judgment in Marex. What he said, I'll just read it to you. Summarising the discussion to this point, it's necessary to distinguish between, and your Lordship will remember there were two categories. The first, cases where claims are brought by a shareholder in respect of loss which he has suffered in that capacity in the form of a diminution in share value. And the same wording, my Lord, is taken up at paragraph 56 in the Primeo judgment advice, where it's said, and again I won't take you back to it, as Mr. Smith submitted, according to the analysis of the majority in Marex, the focus is on the nature of the loss, which involves consideration of the capacity in which the claimant suffered the loss and the form of the loss. So, my Lord, in our submission, the form of the loss is a key part of this analysis, and the form of the loss here is clearly not a diminution in value of shares. So, in our submission, the principle simply doesn't apply to this claim for those reasons. Now, the respondents deal with this in their skeleton argument, my Lord, and I could ask you to turn that up. It's in the call bundle at tab 11. At page 221. So that's call, sorry, 12. My tabs have got mixed up. I apologise, maybe it's 12 at 221. So that's paragraph 34. You'll see at 34.1, they say that had the call option been exercised, the appellants would have been entitled to receive a payment from the AA for the purchase of their shares. 34.2, they refer to the formula provided in the agreement. 34.3, the contractual formula provided for the price payable on the exercise of the option to be calculated by reference to the earnings multiplied by a multiplier plus excess cash. And at 34.4, they say it's broadly the way the claimants seek to quantify the value of their shares on their primary claim. But with respect, this, in our submission, attempts to characterise the loss by reference to the amount of the loss rather than the nature of the loss. And that isn't with respect the right test. It's the nature of the loss, which in this context is the loss of contractual entitlement. It is not diminution in share value. The second point, my Lord, is made in the skeleton at paragraph 55. Where you'll see in 55.2 at the bottom of page 228, they say that the appellants contend that the relevant damage is the loss suffered by the appellants, their personal contractual entitlement. That, however, wrongly conflates the contractual right to receive the payment in the event that the call option was exercised by the APA with the value of the appellant shares in the event that the call option were to have been exercised. This again, in our submission, is simply wrong. The basis of the pleaded laws is that due to the defendant's breach of the investment agreement, the right under clause 12 never arose. It's not our case, it's not the basis of our loss that the contractual right arose but was not worth what it should have been.
So what didn't arise? The contractual right?
Yes.
Or the option? Are you saying the option didn't arise?
The option, yes.
The option. The option was conditional, was it? On what?
Well, the option, as it were, is the option.
We think you are right about this. The exercise of the option depended on the option conditions being satisfied, and the option conditions required EBITDA to be above a certain level.
Yes.
Yes, I see.
And your complaint is that that never occurred, the condition was never satisfied, therefore the option didn't trigger in your favour.
No.
Because of the breaches of good faith, etc.
Yes, and I think that's precisely the case. And those are the two arguments against us. And going back to the judgment, my lord, it's in paragraph 115. You'll see that that's the top of page 91 in the core bundle. My judgment that this claim is barred, even if the claimant's objections are accepted, this claim still satisfied all 6 of the conditions set out from Lord Reed. The shareholders have suffered loss in the capacity of shareholders. Their loss is the value of their shares has been diminished as a consequence of loss sustained by the company. That simply isn't right in my submission. He says the company has a cause of action against the same wrongdoer. Well, he doesn't, the company certainly doesn't have any claim in relation to clause 12. As we've seen, what it may or may not have is a claim for the underlying breach of contract. So, my lord, we would respectfully submit that the judgment should be overturned in relation to this aspect, even if you were against us on the deceit and main breach of contract claims.
Can I just go back to your pleading for a moment? Page 149, tab 9. You say, had it not been for AA's development breach of contract, it would have exercised the call option under clause 12 and paid the consideration. But I think in the way you've just explained it, your claim is that because of AAD's breach of contract, the option conditions were never satisfied.
Yes.
With the result that AAD could not have exercised the option, and that if AAD had performed its obligations, those conditions would have been satisfied, and AAD would have exercised the option.
Yes, my lord, that is correct.
So there's
Yes.
a step missing in the
Yes.
causal sequence.
Yes, you're not right. Lord, in our submission, it's quite clear that the prudential principle does not attach to this part of the claim for all those reasons, and that this part must proceed to trial. And if we're right about that, there will be a substantial claim in the region of £30 million, or whatever the appropriate calculations show, which will be going to trial in any event. And I would submit that if this case is going to trial, the Court of Appeal might take a rather different view in relation to other aspects of the case, as to whether they should be struck out as being fanciful at this stage, rather than being allowed to go for a proper and detailed analysis and finding of fact by the judge at trial, at which point the AA has lost none of its points on reflective loss, and can argue all of them at that stage. So, my Lord, that's reflective loss. I now go on, I hope fairly speedily, to the settlement agreement point, which is our third ground of appeal. And the court will need the supplemental bundle.
Yes.
So, my Lord, in the supplemental bundle at tab 5 is the agreement, and at tab 6 is the claim letter, which I'll take you to in a moment. The agreement is a standard form ACAS agreement compromising an employment tribunal claim. We can see that Mr. Asplin is the claimant and AA Developments at the top, which is our respondent, is one of the AA respondents. There were a number of others. The first clause in the agreement towards the bottom of that page says the claimant shall forthwith withdraw the claims with a capital C. And although that's not defined, we can see that a little higher up the page is the term claims in capitals with the two employment tribunal claim numbers, which are referenced further above as case numbers in the bottom line of the box. And it reflects a settlement reached on the 22nd December 2020 as a result of ACAS conciliation in relation to an employment case. And the court will see at paragraph 3 the amount to be paid to Mr. Astley was £60,000. Before moving on, I would submit that objectively, as a matter of context, it would be very surprising indeed if in this agreement, for that sum of money, in the context of an unfair dismissal claim, Mr. Astley gave up substantial High Court claims for millions of pounds in proceedings yet to be commenced against the AA by the shareholders. It would seem, and I would submit, to be a very unlikely consequence intended by either party of this agreement, given its context. But if we go over to clause 4, my Lord, at the top of page 117, the claimant accepts the settlement monies in full and final settlement of the claims and of any other claims with statutory, contractual or common law which the claimant may have, claimant has or may have against the respondents and or any associated or subsidiary company, business, partnership or undertaking, their directors, officers or employees, whether arising out of the employment, its termination or otherwise, excluding claims of personal injury of which he is unaware at the date of this agreement, accrued pension rights, and claims to enforce the terms of the agreement and any High Court claim in relation to the claims specifically referenced in the letter from Stewart's dated 27th August 2020. And as the court will have seen from the judgment and the skeletons, it's the last part of that provision which has given rise to the dispute now before the Court of Appeal. And in particular, the words claims to enforce the terms of the agreement and any High Court claim in relation to the claims specifically referenced in the letter from Stewart, etc.
Claims to enforce the terms of the agreement must mean this agreement.
Yeah, this agreement,
Yeah.
that's right. Which you would expect in like a Tomlin order.
Yes.
Which is fine. But the clause is, the definition at the end, the excluded claims, the clause is dealing with claims in the context of an agreement which is settling unfair dismissal claims. And if you could look at page 119 at the end, paragraphs 13 and 14. If the claimant brings or commences any legal proceedings or claims intended to be settled other than the excluded claims, the claimant will immediately on demand pay the respondent such sum as necessary to meet any awards and costs, etc. And 14, in any event, notwithstanding 13, if the claimant brings or commences any legal proceedings or claims intended to be settled, the respondent shall be entitled to set off the settlement monies. So the entirety of this agreement, in my submission, my Lord, is dealing with claims. There is no mention anywhere of causes of action within claims. It simply doesn't condescend to that sort of detail. The whole agreement is concerned with claims, and in relation to the excluded claims, it's those specifically referenced in the Stewart's letter. Now, that document, the court will see, is at the next tab, tab 6, page 121. It's a few months prior to the settlement agreement we've just looked at, which was in December 2020. And it was the initial claim letter. Now, the court will see that the position is set out on the first page. We write to notify you we act on behalf of the founders and the former shareholders at Motoriety, noting the previous correspondence with Mishcons. We've already been aware that our client's claims by MDR, and note the correspondence between the parties regarding the provision of pre-action disclosure. The AA has provided some disclosure. We understand there remain extant further pre-action disclosure requests. So this, although it's not, as it were, before the court, there isn't any dispute that there had been Mishcons previously acted for my clients, and while they did so, made an application for pre-action disclosure against the AA, which had resulted in some disclosure. In other words, there was an ongoing dispute in the correspondence, both as to disclosure and as to the claims generally, which were now being made the subject of a formal claim letter. So that we see over the next page on paragraph 6 that the letter is written in accordance with the pre-action obligations pursuant to the PDPAC. The factual background is then set out at some length, and I'm not going to take you through it in detail. You will see, just glancing through it, that it's similar in some ways, very similar to the pleaded case, which is now in the amended particulars of claim. The top of page 128, the investment agreement is dealt with. And then on the next page, the letter sets out in some detail under the heading events subsequent to the investment agreement, the way in which the AA conducted itself seriously damaged the business and then pushed it into administration. the same again, similar to the pleading and the amended particulars of claim. And at paragraph 47, the bottom of page 130, by late 2016, it was apparent the AA had chosen to adopt a deliberate strategy of creating obstacles and challenges for Motority's business in order to avoid potential financial commitments pursuant to the terms of the investment agreement, while simultaneously manoeuvring itself into a position to acquire the entire share capital for a nominal amount, which it subsequently successfully achieved. And then over the page there is the legal basis for the claims. I just pause it there. The two claims which the AA say have been compromised are the services representation, which we'll see in a minute is not referred to in this document, and the contract claim, because it doesn't contain any claim for breach of contract. Although, as the court has just seen, the lengthy exposition of the background includes all those matters, or most of those matters, which are in fact relied upon now for the breach of contract claim, including particularly paragraph 47, which I've just shown the court.
I mean, plainly, paragraph 47 matters are relied on in support of the claim of breach, but there is nothing in this indicating any contractual obligation.
No, it doesn't plead contract at all. No, it's the facts are set out. But as we see, if we go over to 131, paragraph 48, in the light of the facts and circumstances, the claimants have actionable claims for fraudulent or negligent misrepresentation and or pursuant to Section 2 of the Misrepresentation Act. The claimants reserve the right to plead any further cause of action in due course. So, one wouldn't be surprised, one is not surprised to see that in a letter of this sort, given the nature of the allegations and the ongoing inquiry and correspondence that was taking place. So the letter, when we go back to the settlement agreement, which is referenced in the settlement agreement, this letter itself says that the claimants are reserving the right to plead any additional cause of action in due course. The claims that were then set out are there's the falsity of the representations is dealt with in 49 and following. The allegation of knowledge is particularised on the next page, 132, 53, 54 and 55. And then reliance, causation, damage and loss. And at the end of the letter, next steps, we invite you to consider the facts and respond. We do not have a positive response within the timescale. We advise the claimants to take all steps necessary. So that's the letter. And if I could ask the court to go back to the previous tab, to the clause that we are considering.
You really want to read paragraph 4 as though it excludes High Court claims in relation to the facts referred to in the Stewart's letter.
That's the respondent's position. They want to exclude those words altogether.
Well, it's your position, isn't it? You say, well, the facts are all set out in the letter, and claims in relation to those facts are claims in relation to the claims specifically referenced.
Yes. The words of inclusion we would submit in relation to, and any High Court claim in relation to the claims referenced in the letter from Stewart's.
What claims are, quote, specifically referenced, unquote, in the letter? I would have thought it's the misrepresentation claims.
Yes.
So you say any High Court claim in relation to the misrepresentation claims?
Yes. And given that...
Now, the misrepresentation claims all take place before the contract is made.
Yes. And
because they induce the contract.
And the contract's entered in reliance upon them.
Yes.
And
so post-contractual breaches, you say, are how are they specifically referenced?
Well,
By reference to a pre-contractual misrepresentation claim.
well, yeah, the facts, my lord, as we saw, I mean, there's a whole section in the letter that we looked at, culminating in paragraph 47, which specific from 37 to 47, which sets out in detail what happened following the investment agreement. And as it were, what isn't done in the letter is the punchline, and as a result of that, you're obviously in breach of contract. That's what's not said. But in a settlement agreement that is concerned not with causes of action, but with claims, a High Court claim in relation to the claims specifically referenced in the letter from the stewards, in our submission must include the present claim, which not only contains the claims that have been specifically referenced, but also arising out of the same facts, the contract claim, and indeed the further misrepresentation claim in relation to the services.
I mean, just on the contractual point, if you look at paragraph 34 of the steward's letter, it's sort of saying the reverse of there was a contractual obligation. It's saying, although it didn't contain any express warranty regarding the manner in which the service is to be warranted, that was because the AA had conveyed to the claimants that defining the necessary obligations would be time-consuming and so on. So it is talking about contractual obligations, but it certainly isn't saying there was one.
No, not an express warranty, no. But of course our case is not that, as my lord noted. It's a
you say an implied obligation.
implied obligation of good faith, yes.
You don't say that either, and you don't say it was a relational contract in the nature of a joint venture.
No, not in the letter doesn't say that at that point. So what on that basis, the court is being asked to construe those words. The excluded claims include any High Court claim in relation to the claims specifically referenced in the letter in circumstances where, as I showed the court, the letter specifically reserves the right to plead other causes of action in, obviously meaning in any subsequent High Court claim, because that's the only meaning you could sensibly have. That consistent with what's in paragraph 48 of the letter, that is exactly what has happened, that they have pleaded other causes of action arising out of the same facts and concerning the same transactions, particularly the investment agreement.
I mean, I know you say claim doesn't mean cause of action. Would you accept that it couldn't be said that any cause of action, which was merely the subject of the reservation, had been specifically referenced?
Well, that isn't what's said, my lord. And the use of the word claims it's a almost generic use throughout this document, and what it clearly relates to is legal proceedings or claims within legal proceedings, just as this agreement itself relates to the employment tribunal claims. And if one is then presented with as a High Court claim, which is in relation to the claims in the steward's letter, but as anticipated in that letter, foreshadowed in that letter, has included other related claims for breach of contract and a further misrepresentation. To suggest as a matter of construction that the parties in this employment agreement intended to exclude, as it were, not include within the excluded claims definition those claims, cannot in my submission be right. There is no sensible basis upon which either of the parties would have intended to do that. It's simply a form of words that's been used to make sure that the shareholders' High Court claims are not accidentally compromised by this agreement.
Yes.
So that's ground 3, and those are my submissions.
Yes, thank you, Mr. Arnold. Mr. Thompson.
May it please my lords, my lady. If I may, I'll just start with some opening remarks and then a road map as to where I'm going. Clearly, I'll deal with the reflected loss point first and come to the settlement agreement at the end. As regards to the reflected loss point, there are essentially 2 overarching points here, which really, in our submission, provide the key to this case. I mean, the first is that the relevant principles, the principles relevant to this case, have clearly been settled by the Supreme Court in Marix. And there's no scope for any significant development of the law in that area that's remotely relevant to this case. And the second, and really the most important fundamental point in our submission, is that the claimants here have pleaded a paradigm case of reflective loss. And they attempt to get away from that, but they simply can't, because that is what their pleading says in black and white. And that's actually, in our submission, the answer to pretty much all of the points they take on this appeal. They have pleaded themselves a case of reflective loss. And that pleading isn't some accident or horrible error, because it's hardly surprising given the nature of the underlying transaction in our submission, which, of course, is an agreement under which a new 50% shareholder has come in to invest in a company. And it's an agreement involving that new shareholder, the defendant, the existing shareholders and the company. And the agreement, as we've seen, covers not only the terms of the investment, but also how the business is going to be conducted in the future, particularly in relation to the implied terms that are relied on. And so in that context, it's hardly surprising that a claim of this sort made by the claimants, the individual shareholders, runs foursquare into the reflective loss principle. And as a result, this claim is clearly, the court can in our submission see at this stage, flawed and bound to fail on grounds of the reflective loss principle. So, my lord and lady, what I'll deal with is the reflective loss principle first, as I say, and I'll deal with it in this order. I'll say briefly what I need to about the principle. I'll then look at the pleading, and I know the court's been shown the pleading, and I can do this quickly, but it's critical that I show the court the crucial bits of the pleading for our case. Then I'll deal with the main case, so this is pre-amendment, the diminution, the claim that it's accepted by the claimants is for diminution in share value. Then I'll deal with the alternative case relating to the call option. And then finally, quickly with the initial investments amendment, which is also relied on. And then I'll finally just at the end deal with the argument that it's not appropriate to strike out because there are various uncertainties as regards the law and the facts according to the claimants. So starting then on that roadmap and looking first at the principles and the law in relation to reflective loss, the first point, and this isn't contentious, of course, is it is a substantive rule of law. It goes to jurisdiction, it's not really a matter of discretion, and that's actually set out in the decision of this court in Day v. Cook, paragraph 38, which just, we don't need to turn it up, but for the court's reference is bundle 1 of the authorities, tab 5, page 119. And that, of course, is also borne out by the Marix decision of the majority. And the majority in Marix, as we've seen, identify the nature of that substantive rule, namely that certain loss is simply not recoverable as a matter of law if it falls within the reflective loss principle. Now, my lords, my lady, the court's been shown the Reed case, and I don't need, I think, to take the court to the key principle again. If I could just remind the court of the relevant paragraphs, it's put in entirely consistent but slightly different ways, really, in the following paragraphs. 9 at page 398, 39 at 406, 67 at 414, 79 at page 417, and 89 at page 419. And those page numbers are the pages of the bundle. It's paragraph 79 that's perhaps the best statement of principle, and that's the one which the judge, at first instance in this case, relied on in identifying the relevant principles. Now, an absolutely critical point in this case, it appears from the learned friend submissions, is that the loss of the company does not have to be the same as the shareholders' loss. The quantum may be different, and indeed there may be no close correlation between the harm to the company and the loss to the shareholder. And that is to answer a question that my Lord Justice Newey put to my learned friend fairly early on in his submissions. And that's entirely clear from various paragraphs of Lord Reed's judgment. I should take the court now to those, because that is essentially the wriggle room that the learned friend is trying to invite the court to find in his favour, to say, well, it's all terribly factually difficult, the learned friend says, and to see whether it really is reflective. One's going to have to get to trial and go into the facts and see whether actually the company's loss correlates with the loss to his clients. And the answer is, as we'll see in a moment, it doesn't matter. It's not relevant to the application of the reflective loss principle. There does not have to be a close correlation between the two at all. So if we could, if I could invite the court, please, to look at Mareks again. So it's volume 2 of the authorities bundle at tab 13, please. The first paragraphs, and it's a point that appears in several places. The first place is paragraphs 32 and 33 on page 403 of the bundle, please. And this is part of the judgment of Lord Reed, which is dealing with the rationale for the rule. And it's looking at the rationale for the prudential rule. And at 32, Lord Reed says, where a company suffers a loss, that loss may affect its current distributions or the amount retained and invested in order to pay for future distributions. Since the value of a company's shares is commonly calculated on the basis of anticipated future distributions, it is possible that a loss may result in a fall in the value of the shares. That is, however, far from being an inevitable consequence. Companies vary greatly, and the value of their shares can fluctuate upwards or downwards in response to a wide variety of factors. Skipping to the last sentence of that paragraph, a problem only arises where, as in Prudential, a shareholder claims that the company's loss has had a knock-on effect on the value of the shares. And then going on to paragraph 33, still dealing with the rationale for the rule, if I could invite the court just to turn over to the end of 33, please, on page 404.
Can you explain the second sentence of 33?
I think my lord was absolutely right. It assumes that there's a claim by the company as well. It does just assume that. I entirely accept that. So, going over, if you would, to page 404 and the last two sentences of paragraph 33 right at the top. Lord Reed says, as I've explained, however, there are also circumstances where there may not be a close correlation between the company's loss and any fall in share value. The avoidance of double recovery cannot therefore be sufficient in itself to justify the rule in Prudential. So this is part of his reasoning that actually it's not a double recovery based rule. It is based on not subverting the rule in Fuss and Harbottle, as we've seen, as he comes to in a moment. And here he's pointing out one of the reasons why it's not about double recovery, or at least that is not the driving rationale behind it, is because it's going to apply even where there isn't a close correlation between the company's loss and the shareholders' loss.
I mean, I suppose he would more obviously there have in mind that the fall in the share price might not be as great as the loss to the company.
Indeed. he's not being clear as to which it is. That's one possibility. He's making the point, though, that it's not about double recovery because there isn't necessarily a close correlation. And even where there isn't a close correlation, the rule still applies. As he makes clear, we'll proceed on to look at the other references to this point. And we'll see, we don't need to look at it again, the court's seen it, paragraphs 35, 37, 38. He explains what he does regard as being the rationale of the rule, as being not subverting the rule in Fuss and Harbottle, and in particular the fact that, as it's put importantly at the bottom of paragraph 37 on page 405, that the point is that a shareholder in investing, becoming a shareholder, agrees to follow the fortunes of the company and creates, as it's put in the last, or the penultimate line of that paragraph, a unity of economic interest that bind the shareholder and the company. And then if we could please go over to paragraph 42 on page 407, quite an important paragraph, because this is where Lord Reid is dealing with Lord Bingham's speech in Johnson and Gore Wood, and he actually refers to the, this is the, if one, he refers here to the first category, so Lord Bingham's proposition 1, and 5 lines down into paragraph 42, he refers to the third sentence of that. And that's the sentence that the learned friend alighted upon earlier, which appears to suggest that there might have to be some identity between the two losses, the loss of the company and the loss of the shareholder. And Lord Reid very importantly says, 5 lines in, the third sentence should not be understood as limiting the rule in prudential to cases where there is an exact correlation between the company's loss and the fall in share value. As explained in paragraphs 32 to 38 above, it's possible to envisage cases where there is not a precise correlation and where recovery by the company might not therefore fully replenish the value of the shares, but where the rule in prudential would nevertheless apply.
So I suppose just going back to my last question, I suppose that last bit there is envisaging a situation where the company might not have lost as much as the shares have lost value.
Yes, or where, for whatever reason, because of the various factors that affect share value, full replenishment of the company's loss doesn't necessarily translate into the loss in share value that is claimed by the claimant shareholder.
Well, the forward multiple may have dropped for whatever reason because the
yes.
company had
Well,
a
yeah.
difficult time.
Indeed, as is pointed out by Lord Reid earlier on this judgment, companies come in all shapes and sizes. Public companies may be very different to private companies as regards this link between their assets and the value of the shares. And he's simply making the point, which is in this context quite an important one, as I submitted, that for the prudential rule to operate, one doesn't have to identify an exact correlation between company's loss and share value.
I mean, I follow that. I thought with the earlier passage, maybe he would more obviously have had in mind a situation where the shares hadn't fallen by as much as the company had lost. But this seems to be the other way round. The shares might have fallen by more than the company has lost.
Yes, I think the...
You say the governing principle is there doesn't have to be a correlation.
It doesn't matter which way it is. And both ways are possible, of course, because what he's thinking about here, because he's dealing with this particular sentence in Lord Bingham's judgment in Johnson that we looked at, he's considering the possibility that recovery by the company, replenishing the company's loss, won't necessarily fully make good the claim by the shareholder that he's lost value in his shares.
I mean, as my lord says,
he's
the
dealing with
multiple might have changed.
Indeed. He's dealing with it in that direction because that's the point that appears to come out of the sentence in Lord Bingham's judgment. But it would apply in either direction. Because, of course, the loss to the company can come in multiple forms. One tends to look at this in terms of simple cases where there's a misappropriation of company asset. We've got the famous cash box case used because it's, on the face of it, simple. But, of course, the reality is, in commercial context, it's often anything but simple. And you don't, the key point is, clearly from this one doesn't have to go and identify an exact correlation between the two, and the discrepancy can be in either direction. And just to finish the point off to make it absolutely clear, there's the last sentence in paragraph 49, which is on page 409, where pithily Lord Reid says the rule in prudential is not premised on any necessary relationship between a company's assets and the value of its shares or its distributions. And then paragraphs 80 to 81, which are at the end of the judgment summarising the overall position. This is on page 417. Two-thirds of the way down, paragraph 80, Lord Reid says, depending on the circumstances, the company's recovery of its loss may have the effect of restoring the value of the shares. 81, there may, however, be circumstances where the company's right of action is not sufficient to ensure the value of the shares is fully replenished. And skipping down 6 lines, still in paragraph 81, just at H, but the effect of the rule in Foss and Harbottle is that the shareholder has entrusted the management of the company's right of action to its decision-making organs, including ultimately the majority of the members voting at the meeting. The rationale for the rule and the rule itself in prudential applies regardless of the closeness of that relationship. And just for completeness, Lord Hodge at page 422, paragraph 99, letter, or just above letter E, he says, I agree with Lord Reid that what the court was saying is that where a company suffers a loss as a result of wrongdoing, that loss is reflected to some extent in a fall in the value of its shares or its distributions. The fall in the share value and the distributions is not a loss, which the law recognises as being separate and distinct from the loss sustained by the company. So there has to be some causal link. The loss in share value or in distributions that the shareholders are claiming has to flow from, to use the language of Lord Reid, the harm done to the company. But that's the extent of it. There doesn't have to be a close or direct relation.
If there's no harm done to the company, then the fact that the claim is measured by reference to company profits or distributions is not itself a bar, as in the personal injury claim by Mr. Lee or Mr. Sheehan, whichever one.
That's exactly. That's exactly an example of that. So the various, you can't. It's not good enough just to say, oh well, it's a claim for diminution in share value, because that's only one aspect. That's only one part of the criteria. So I don't think I need to say anything more about the rationale for the rule. I think that is clear. It's this appeal doesn't really turn on that, although it's important in applying it just to recall what its underlying driving rationale is. Now, the important point, therefore, is that if loss in share value claimed by a shareholder is to fall outside the reflective loss principle because it is separate and distinct from the company's loss, actionable loss. That has to be because the loss in share value does not flow from the company's loss. That's what separate and distinct means. And I'll now take the court to what's actually been pleaded. But what has been pleaded is expressly a loss in share value suffered, it's said, by the claimants, which on the face of the pleading very clearly flows from actionable harm suffered by the company. And if it would help the court just to have an example of a situation where there is separate and distinct loss. There's the case of Howard and Wood and Matthews, which is, we can look at it if we need it. It's the third in the first volume. It's referred to in both Johnson and in Marrick's. That's a case where negligent advice by solicitors given to the company and to the company's owner shareholder resulted in the company not being able to take advantage of statutory provisions that allowed a lease to be renewed. So instead what happened is the company had to go negotiate a new lease with the landlord. And the claim was that those terms weren't as good as the statutory terms that should have been obtained with the benefit of non-negligent advice. And what was being claimed by the shareholder against the solicitors in terms of loss of share value wasn't loss arising from the harm suffered by the company because it ended up with worse terms under the lease that it in fact had to enter into, but the loss in share value that was caused by the fact that the shareholder himself ended up having to agree with the landlord as a term attached to this lease that he wouldn't dispose of his shares for 3 years. And so that's loss in share value that's suffered, in this case, by the claimant shareholder. But it doesn't flow from the harm suffered by the company. It flows from some independent harm done to the shareholder. So that's just an example of how, in fact, you can have separate and distinct loss that doesn't flow from harm done to the company. So, my lords and my lady, could we look, I'll do this as quickly as I possibly can, but it is important, again at the amended particulars of claim. I just want to highlight the bits that are in our submission critical. So it's tab 9, and I will do this as quickly as I can because I know you've read it through and you've seen it from the perspective of a learned friend. So, if I may, I'll turn the pages and then summarise where we get to. And I want to look at the misrepresentation claim first, get to the end of that, then come back and do the contract claim. So misrepresentation, if we could start at page 108, 2.3.1 at the bottom of the page, it said that substantive discussions between the claimants and the company, on the one hand in AA Developments, commenced in February 2015, and that the company and its shareholders and managers were principally represented by Ms. Burnford and Mr. Astley, C1 and C2. If we go over to 111, this is the first of various pleas of particular meetings. This at 2.7.1 is a meeting on Friday, 27th of February, where Mr. Burnford and Ms. Burnford and Mr. Astley are said to have acted on behalf of the claimants and the company. And then if we go to 113, there's another such meeting, 6th of March, same thing. Mr. Astley on behalf of the claimants and Motoriety met with AA Developments. And then over the page to 114, 2.10 at the bottom, same thing again, another meeting. Here, Burnford and Astley acting on behalf of the claimants / Motoriety. And then going over to 116, we've got a meeting on the 24th of March, 2.12.1, same thing. Burnford, Astley, Fitzpatrick and Knox on behalf of the claimants and Motoriety. Next page 117, 2.13.2, same thing, meeting 14th of April. Again, Burnford and Astley on behalf of the claimants.
I think we've got the picture.
So it carries on. I shan't bore the court with more, but the whole point is that here are the negotiations that are said to have given rise to misrepresentations, and these have been conducted on behalf of both the claimant shareholders and the company in tandem.
Yeah, well, you get that gets picked up in 3.1.
Indeed. And so we then get the representations. I'll come to that just in a moment, my lord. We go to 119. The heads of terms are entered into by the company. We see that at 2.17 at the top of page 119. And it's said at 3.1 on the same page, representations to the claimants and Motoriety. That's the immediate access representation. And if we go over the page 120, the reliance, this is quite an important paragraph because we've got the representations have been said here to be made with the intention that the claimants and Motoriety would rely on them in preferring AA Developments to Solera, in concluding the agreements with AA Developments, in procuring that Motoriety would conclude the proposed agreements, so that's clearly directed at the claimant specifically, And it's then said the heads of terms, the investment agreement, the license agreement were concluded by the claimants and Motoriety in specific and intended reliance upon those two representations. So reliance pleaded again by both parties.
And just picking up a point, if one goes back to 3.2, where we get the implied honesty representation, that doesn't, in terms, say that it was made to Motoriety as well as the claimant.
No.
But A, one might think that it was ancillary to 3.1, which is to Motoriety, and B, if you've got reliance, then it has to be made to Motoriety in the first place.
Absolutely not. And it's 3.2 is said to be in making the immediate access representation. That's the one in 3.1.
Yes.
Impliedly, there's this supposed representation of honesty. And then going back to 120, we've got the business plan, which is said to have been worked on by the claimants, Motoriety and AA Developments. And if we go to 122, it said at 4.7 the business plan was prepared, contributed to and accepted by the claimants and Motoriety in reliance upon the two representations identified above.
Sorry, I wasn't keeping up.
Sorry, my lord. 4.7, page 122. The business plan is said to have been prepared in reliance on those representations, and it's said to have been prepared by both the claimants and Motoriety and accepted by them. So again, it's the two relevant parties for this purpose, claimant shareholders and the company, again in tandem. The heads of terms is just with the company, as we've seen. If we could go to 124, we'll see then at 6, reference to further discussion. So these follow the heads of terms in May 2015, and it said that discussions continued between AA Developments and the claimant / Motoriety again, for the purposes of concluding formal agreements. And then at 6.1.2, these discussions were in substance a continuation of the discussions referred to above, with involved AA Developments on numerous occasions confirming the immediate access representation, associated implied representations, with the intention that the claimants and Motoriety would rely on them in concluding the intended agreement. So again, claimants and Motoriety. There are further drafts of the business plan, 6.3 on page 125. It said as far as the claimants and Motoriety are concerned, business plan prepared in good faith. Over the page to 126, we've then got the investment agreement, 7.1, which, as we know, has now the claimant, shareholders, and the company as party. And if we then go to 128, there's a paragraph 7.6, heading reliance.
I thought we were going to deal with the misrepresentation claim first. We're now looking at the contract.
Well, no, only insofar as the contract is said to be how they relied on the representations. No, but I will. I'll avoid the actual terms of the contract, yes. So, reliance on the representation, 7.6 on page 128. It's the claimants and Motoriety concluded the investment agreement in intended and specific reliance on the representations they referred to.
Yeah. Just picking that up, if one looks at the services representation pleading in 7.5.1, that doesn't refer to Motoriety, but then the reliance is said to be by Motoriety as well as the claimants.
Indeed. And it is absolutely clear that if it's pleaded that a party relied on a representation, it clearly must have been made to it. It's impossible otherwise for it to have been relied on. So there is the odd little glitch where the two don't quite march in step. That is the plea of to whom the representation was made and reliance. Most of the time they do. But if it's said that X relied on a representation, it must have been made to X. We've then got the license agreement, which is just between Motoriety and AA Developments, paragraph 8.1. If we then go over to 130, then we've got reliance at 8.4. The claimants and Motoriety concluded the license agreement in intended and specific reliance on the representations. Now, the claimants, of course, weren't party to the license agreement, so it must be being said that they procured the company to enter into it, which is consistent with what we saw a minute ago at paragraph 3.4 on page 120. And if we skip over then to 10, on 131, it's then said that the representations were false. At 134, it said that they were made fraudulently. At 138, it said alternatively negligently. And we can then skip the events after the agreements because they're not relevant to misrepresentation, and go to 146 if we could, which is where we pick up loss, damage and remedy. And 16.1 is specifically misrepresentation / deceit. And this is obviously quite important because this is where the plea of the loss, which we say is reflective, is actually set out. And what it's said here is that the claimants wouldn't have entered into the investment agreement but for the misrepresentations, and they'd have done the deal with Solera instead. And one can see it's the claimants and Motoriety. So it's the claimants wouldn't have entered into the investment agreement, and Motoriety wouldn't have entered into the heads of terms or the license agreement, but would have concluded the envisaged venture with Solera. And if we go to 147, that's confirmed at 16.1.3, where it said in relation to the claim for deceit, claimant's cases, but for the wrongdoing of AA Developments, the claimants and Motoriety would have proceeded to conclude with Solera the transaction substantially agreed by the 11th of May 2015. And then at 16.1.4, it's pleaded what would have happened, they say, under the proposed venture with Solera. Without reading it through, basically they say Motoriety's business would have thrived, they allege, under the hypothetical venture with Solera. And if one goes over the page to 148, we then see the loss that's said to have arisen. At 16.1.5, it said the value of the claimant's shareholdings in Motoriety would be the subject of expert evidence. Without prejudice to this, the adjusted EBITDA for Motoriety is likely to have been, so that's if there had been a Solera venture, in the region of at least £5.45 million, and with an approximate multiple range, 7.5 to 9.7, that would have produced an approximate enterprise value for Motoriety at the relevant time of 40 to 53 million, and equity value 46 to 59 million.
Curiously enough, it doesn't actually say that that's the loss.
Well,
no,
no.
I think it must be implicit.
It must be implicit. I mean, they do plead earlier. We'll see it when we look at the breach of contract bit in a minute. They plead, of course, that the company went into administration. So the counterfactual is deal with Solera. The actual fact is company goes into administration, it's worth nothing, shares are worth nothing. And so what's implicitly being said here is, well, our shares ended up being worth nil, in fact.
And this is what they would have.
And they would have been worth, they say, up to 59 million, or at least the total shares in the company would have been worth up to 59 million, if in fact the Solera deal had gone ahead.
It's sort of a bit more explicit if you add in Schedule 1A at 153.
Yes.
Because that's headed Schedule of Loss and Damage.
Indeed. Indeed.
And then you get loss of claimant share value. So the loss of claimant share value must be the alleged loss and damage.
Yes, and they don't give any credit for any value they say the shares actually had, so basically the shares are worth nothing in fact, which is clearly the case if the company's gone into administration. But what one can see from that, therefore, is that the loss in share value claim that's put here is put squarely on the basis of the performance that they say the company would have had and the profits it would have made under the Solera venture, as compared to what in fact happened, which was insolvent failure. So that's the misrepresentation claim. And if I could just fill in the gaps for breach of contract, please. Sorry, I have skipped a final stage on the misrepresentation claim. As Lord Justice Newey pointed out, you've then got the schedule, page 153, which actually breaks down by particular claim.
And of course, it does include the loss of initial investment claim as well as the loss of share value claim.
But that's put as an alternative. I will come back to that. I'll deal with it separately. So if we could go back, please, to page 130, that'd be great. We'll see there the obligations of good faith pleaded under 9. And what it said at 9.2 is, this is quite important in the context of submissions Malone and Friend made, there were implied terms of the investment agreement and or, as necessary, the license agreement between Motoriety and the AA. I'm going to make some submissions about this, but just to flag up the significance of that, Malone and Friend was seeking to suggest that perhaps the company wouldn't have a cause of action for breach of contract on the basis of his pleading, because he was trying to suggest that, or perhaps the obligations might not be owed to the company, these implied obligations that he alleges, but only to the claimants. I'm going to come back to make fuller submissions about this, but one can see, just looking at this, that it's part of his pleaded case that these obligations were owed to the company under the license agreement, because the court will remember the license agreement only has 2 parties, the company and AA Developments.
Well, I mean, I can see why in that sort of an agreement there is, so to speak, or arguable there is a joint venture of sorts. The 2 companies between them are going to exploit the particular product. I find it a bit more difficult to see how there can be an implied term of good faith between a shareholder and a company in which he has just invested. I suppose it's possible.
I would with respect agree with my lord, but of course the case is being put by the claimants, the appellants, the other way round. They're saying, oh, well, there might be an implied obligation owed to us as shareholders, but not to the company.
Yes, well, the joint venture vis-a-vis Motoriety is as between its shareholders. Why would a shareholder owe the duty of good faith to the company in which it's just invested?
Oh, well, I will come back to this, but just to answer that one. Because what we've got here is we've got the AA Developments is coming in as a 50% shareholder. It's reaching an agreement with the company as to how the business is going to be conducted. It's providing its brand under the license agreement. It's on the case that's advanced. It's agreeing to provide access to its customer base. So it's taking an active part in this. True, some of the shareholders are as well as directors, C1 and C2, but a lot of them are just silent investors. But the venture that's being put, and we're just doing this on the basis of the pleading case,
Yeah.
the venture that's being put is one which was centrally between all of these parties, in fact. The shareholders, the claimant shareholders, AA is the new 50% shareholder, and the company.
Yeah.
The point I'm simply making at this stage is, as pleaded, it is pleaded that these obligations, under as implied terms of the license agreement, were owed to the company.
Yes.
So that just dispatches that point in time. But I will come back to it. I'll deal with it fully. So these are the implied obligations relied on. And then if we go to 138, we'll see the heading, the long section, relevant events after the agreements. And these set out a number of complaints, really, levelled at the defendant as regards matters to do with the conduct of the company's business. So we've got 13.1, A's failure to market Motoriety's products. 13.2 on page 139, we've got complaints about the number of customers to whom the services could be marketed. At 13.3, 140 complaints about the activities of the defendant's central marketing function. Specific complaints are made there. 13.4 under the heading General, it said a number of further material acts or omissions on the part of the defendant which seriously damaged Motoriety's business between September 2015 and April 2017, In particular, as explained below, failure to meet forecast revenue targets due to 2 key products being delayed, and 13.4.2, AA developments embroiled Motoriety in a retail parts project, and the project were autonomised to become part of AA's membership arrangements, and then refused or failed to proceed. And those particular complaints are then set out in more detail at 13.5, 13.6 on page 141, and then 13.7 and 13.8 on pages 142 and 143. And then at 13.9 and 144, it's alleged that AA adopted a deliberate strategy of creating obstacles to Motority's business with a view to acquiring it without having to pay the earn-out consideration under clause 12. The point about all these things is they're all allegations about alleged breaches of contract by the defendant which impacted the company's business. And then at 14 on page 145, under the heading breach of agreement, it said, in the premises set out above, the defendant was in breach of the implied terms of the investment agreement at 9.2, which we've just looked at. It said at 14.2 it wasn't in a position to provide the agreed services of the license agreement, and at 14.3 in the premises set out in paragraphs 13.1, 13.9 above, which we've just skipped over, AA deliberately sought to frustrate the venture with Motoriety and acted in further bad faith, apparently with a view to ultimately acquiring Motoriety. So we can see the nature of the breaches of contract alleged here. Breaches of these implied obligations, which are in contracts with both company and the claimants, and they're all said to have done harm to Motority's business and ultimately forced it into administration. That's the nature of the allegation.
When you say breaches of, I forget the precise words, breaches of contracts with both the company and the claimants, is that slightly question begging? I mean, I follow that there's an express plea, as you were showing us back in I've now lost the implied obligation.
9.2, which is back at page 130.
So we get the bit in brackets.
Yeah.
Bar the bit in brackets, there's no plea that this is breach of an obligation owed to Motoriety.
No. But it's an implied obligation, my lords, said to be owed on the basis of a relational contract and the particular relationship. It's said to have been implied into first a contract to which the company and the other shareholders were parties.
You say if it was an implied term of the investment agreement, it was owed to all other parties to that contract,
Absolutely.
including the company.
Absolutely. And that's even clearer in relation to the license agreement, where the only other party, other than the obligor, is the company.
I mean, if one envisages how it would have been written into the investment agreement, it would be very, very odd to suppose that someone had drafted a clause saying that there is a duty in relation to the provision of information owed merely to the claimants, but not owed to another contracting party of the company.
Absolutely, and particularly when one looks at the basis that it's said to have given rise to this implied obligation, it's said to be the relational nature of the contract. The company is the one with the business who is actually conducting the business, which it is said was in the nature of a joint venture between it and the various shareholders. It would be absurd, we'd actually say, if any such obligations of good faith that arose on that basis, on the basis that it's said to have been a joint venture, wouldn't be owed to the company, and would only for some reason be owed to other shareholders. The company is the one that's conducting the business. If the other shareholders need the protection of that sort of implied obligation of good faith, then so must the company. It'd be quite absurd to draw some sort of line between the two. And I should also say, this is actually a point that's, strictly speaking, not open to the appellant on this appeal, because it forms no part of the grounds of appeal and no part of the skeleton argument to suggest that the basis for the appeal is that there wasn't any cause of action that the company could pursue. The grounds and the skeleton are all directed to the question of whether there's a separate and distinct loss.
Yeah.
It's not so far, certainly as far as I've noticed at any point in these proceedings until now, been suggested that the reason the reflective loss principle is argued not to apply by the appellants is because the company hasn't got a cause of action. It's a hopeless point anyway, but it is actually a point that's not, strictly speaking, open to the appellants. Sorry, ultimately I broke off and diverted from the contract.
Yeah. So you've shown us the contract, you've shown us the
breaches.
allegations of breach.
So it's loss and damage, and that the contract claim starts at page 148, my lord, 16.2, under the heading breach of contract. And here it's important to study the precise words again. It said at 16.2.1, the claimants are entitled to damages on the basis that the venture would have proceeded in accordance with the intended and agreed terms of the investment agreement and license agreement and the business plan, which would have resulted in the company obtaining immediate access to the customer base, meeting or exceeding forecasts, becoming cash flow positive in year 2 at the latest, and surpassing the EBITDA threshold of 1.3 million in year 3. And then this further elaboration of that 16.2.2. And the point is, this is all about the effects that it is said that compliance with the contract as alleged would have had on the company's business. It's all through the medium of the company. And then 16.2.5, it said the value, this is on page 149, the value of the claimant's shareholdings in Motoriety was subject to expert evidence. Without prejudice to that, the adjusted EBITDA for Motoriety for the relevant period is likely to have been, at least in the region of 5 million for 2018, 14 million for 2021. Future maintainable earnings likely to be around 9 million, multiple range 7 to 10, producing an approximate enterprise value between 67 and 100 million, and approximate equity value between 98 and 132 million. So again, it's very similar to the basis of the deceit quantification of loss. It's all about the company. It said the company would have made profits, therefore the shares would have been valuable. And again, we have at 154 the schedule that breaks it down by individual claimant. So what in our submission we have, just to summarise very quickly, in relation to the misrepresentation claim, we've got representations relied on by the claimants and the company. We've got representations made to the claimants and the company. And it's alleged that without representations, the claimants and the company would not have relied in the way alleged. They would have entered into a similar agreement with Solera. Business would have been successful. Therefore, the company's shares, it is said, would have been valuable, whereas in fact, the company's business failed and the shares are worth nothing. So, and it's absolutely plain that the company must, if that is all correct, have a cause of action as well. Because all of the ingredients of the company's cause of action are actually expressly pleaded in the particulars of claim. We've got representations to the company, falsity, fraud, reliance by the company, harm to the company, all pleaded. And then in relation to breach of contract, quickly, because we've covered some of this anyway, we've got the investment agreement with the companies and the claimants, the company and the claimants party. We've got implied terms which we've looked at in both the investment agreement and the license agreement. There's alleged breaches, which if those obligations were owed, as we submit, they must have been to both claimants and company, must have been actionable by both claimants and company. Loss is pleaded in terms of harm to the company's business, which then translates into harm to share value. And so this is why we say this is an express plea of a paradigm case of reflective loss, both as regards the misrepresentation claim and the breach of contract claim. You have actionable claims in each case by both the company and the claimants for deceit and for breach of contract. You have harm pleaded to the company in both cases, and the loss to the shareholders, the claimants, is expressly quantified by reference to the alleged harm to the company, that is the profitability that the company should have had and was deprived of. So it simply is a paradigm case of reflective loss expressly pleaded in front of us. And moving on then from that, my learned friend seemed to suggest that it would somehow be unrealistic, I think he was saying, for the company to actually brought its claim. Now the first point is that that's completely irrelevant under the Marrick's principles. But it's actually wrong. The company went into administration. My learned friend was suggesting, well, how on earth could the company sue its 50% shareholders, he would suggest. Well, it didn't have to. It went into administration. At that point, all the company's claims are under the control of the administrator. If the company had a good claim against AA Developments, the administrator was in perfect position to pursue it. That, of course, is one of the prime jobs of an administrator or liquidator, to realise the company's assets. So it's just wrong to suggest that the company wasn't in any sort of position ever to pursue this claim. And by the way, I certainly didn't suggest at first instance that the answer was a 994 claim. That's part of the rationale, as we've seen in Marrick's case, as to why, given that the whole point of the reflective loss principle is to protect the Foss and Harbottle principle, it is an explanation as to what the escape route for the shareholder may be. But of course, in a situation where the company goes into administration or liquidation, the primary answer is, well, it's for the office holder to pursue the claim.
They also sometimes sell claims, don't they?
Indeed, absolutely. So they may well, they sell claims. There are various routes which the office holder can take between actually pursuing the claim himself with his own money, the assets of the company, through funding, obviously, and through to the other end of the spectrum, just selling the claim often to creditors who are prepared to pursue the claim.
I mean, looking at the unamended particulars of claim, one would rather get the impression that your opponents were not alive to the reflective loss point at the time, in which case they wouldn't have been knocking on the door of the administrators saying, "Can we have the claim?"
Well, perhaps not, but then we don't know.
No.
It isn't really relevant. But actually, given the nature of the pleading, that is, pleading the position of the company throughout, actually it would be rather surprising if they weren't alive to the existence of the claim by the company. It's another thing as to whether they were fully alive to the reflective loss point. That's a different thing. But they must have been alive to the existence of a company claim, given that they effectively pleaded it out. So fundamentally, it isn't relevant. So, moving on, if I may, we then have the application of the reflective loss principle to the original claim. So that's without any amendments. So forgetting about the call option plea and forgetting about the initial investments plea for the the moment. I can deal with this, I hope, fairly quickly, because I've effectively already made the submission. This is an express plea of reflected loss. Now, the answer at first instance, and indeed before this court, that the claimants have tried to make to that is to say, oh, well, this is a separate and distinct loss. But it plainly isn't. It plainly is loss consequential on the harm to the company on the basis of their own pleading. And what they've said in their skeleton argument before this court now is that the judge, they say, mischaracterised the claims because he, and I quote, ignored the fact that the losses for which they seek compensation were caused by independent wrongs committed against them by the defendant. Well, they say they have an individual independent cause of action. Of course they do, because otherwise they wouldn't be able to bring the claim. But that isn't enough to take the claim outside the reflective loss principle. Indeed, the existence of an independent cause of action for the shareholder is, of course, a precondition of being able to make the claim, and it's the reason why the reflective loss principle potentially applies.
The question of the nature of the loss.
Indeed, exactly. Exactly. And the judge put it rather nicely, if I may say so with respect. He said at paragraph 88, while the claimants have a direct claim against the defendant, they've only suffered an indirect loss. And that's the nub of it. So there isn't, I don't really need to say much more about that. It is simply a pleading of a paradigm case of reflective loss. So what I'd now like to do is just look at the attempts to escape from this, because and this is actually an important point when it comes, so I'll jump the gun slightly if I may, when it comes to the suggestion that there may be facts which have to be found which require a trial, and this court can't deal with the reflective loss point. The claimants have had two opportunities to actually add anything they wanted by way of pleading as regards facts that might take this outside the reflective loss principle. There's the two amendments which the court's seen, but as the court will also have noted, we did actually plead a defence, and they have replied. And in the defence, of course, we pleaded the reflective loss defence. So they've had every opportunity, both by way of amendment to their particulars of claim and by way of reply, to add anything that they thought was relevant by way of further facts, which they might argue take this outside the reflective loss principle. And in our submission, nothing significant have they added. So if we can look at the first thing that they have tried to add, that's the loss of call consideration. And my lords, my lady, you've looked at the pleading. It's at 149 in the amended particular claim we've just looked at. It does, of course, relate to the contract case only. Importantly, it's a new head of loss. It relies on the same breach and the same causation arguments. And what the claimants are trying to persuade the court of is that it's not a loss of share value. But in our submission, it really is. Once it's seen that it is actually a claim for diminution in share value, for loss of share value, then there's no reason why it falls to be treated in any different way to the existing unamended claim that we've just looked at. I'll deal with this methodically, but the short point, my lords, my lady, is that it is still a diminution in share value claim, and the only difference is as to the mechanics of valuation. That's the distinction, and it's not a relevant distinction for the purposes of the application of the reflective loss principle. Now, what the claimants are trying to say in this amended head of loss is that if the contracts were complied with, particularly the obligations of good faith, etc., then the company would have made profits, and the defendant would have bought the claimant shares under the call option. at a formula which they say would have resulted in a total figure of just over 31 million pounds. So, of course, it's a lower claim than the 46 to 62 million that they've got in their principal. I'm not sure it is right, as my learned friend I think accepted, that this is a claim to enhanced loss. It's actually, if anything, a reduced figure. And if it were enhanced loss, it's hard to see why on earth the defendant would have exercised the call option if it was going to end up paying more than the shares were really worth.
Well, I suppose it might still exercise the option so it got the shares. I mean, the claimants might otherwise hold out and say we'd rather stay shareholders.
It's a factual question. We've got to assume that at trial, if this goes to trial, they will prove what they allege, namely that the defendant would, for some reason, have exercised the call option. But it's a slight oddity, because you'd have thought actually it's probably a point that the defendant might have taken to say, well, hang on, your loss here is capped, because if your shares were worth as much as you say, we'd have leapt in and exercised this call option. But in fact, they're the ones who are running the point. Now, the key response to the point is really this. It is still a claim for loss of share value suffered in their capacity as shareholders. And that's obvious, because what they're positing, the hypothesis they're positing here, is a sale of their shares to the defendant at a price way in excess of the actual value of their shares, which of course in fact has proved to be nil. So this is just a different valuation mechanism to measure the diminution in value. Their main claim is they want to invite the court to value the shares on the hypothesis that the contract had been complied with, just on a general market value basis. You've seen how they purport to do that. This is instead different only in that what it's doing is saying, well, we're going to invite the court to adopt a specific hypothesis as to what would have happened. So it's not the general value of these shares, it's the value the shares would have had if the call option had become exercisable and the defendant had in fact exercised it. So that's the specific hypothesis, which of course, if that's found to have been what would have happened in fact by the court, that would result in the formula in the call option provisions being applied to value the shares. But it's still a claim that is to essentially the value of shares which they say would have arisen if the contract had been complied with. And the only difference is just how you actually quantify that value. And so for the purposes of the relative loss principle, it's an entirely immaterial difference. And we can see that the actionable harm to the company in the form of the effects of the breach of contract that they allege on the company's business, which they allege, as we've just seen, is still central to this head of loss. This head of loss, this diminution in value of their shares, still clearly flows from the actionable harm to the company. Because first, as my Lord Justice Newey pointed out, to get this hypothetical scenario proved and accepted by the court, they've got to persuade the court that the call option conditions would have been satisfied. I'm not sure we need to turn them up, but
it wouldn't make any difference to your argument if this was simply a contract by AA to buy the shares at a price calculated in accordance with the formula after 10 years, say, or 5 years, or whatever it was. You might have been compelled to take the shares for £1 each instead of £100 each.
Yes, you could have had a situation where the conditions that apply to the call option would simply have been conditions of an obligation to buy. No option, just you've got to buy.
Yeah.
It doesn't really make any difference.
Your argument is that it's nothing to do with the mechanism by which the shares are to be transferred, whether it's conditional or unconditional. It's about the price at which the shares were to be transferred, if at all. And if the price for those shares is to be measured by reference to the profits that the company is making, then any actionable harm to the company which causes those profits to diminish or disappear completely is then reflected in the share price that the formula would produce.
Absolutely, absolutely. And at risk of slightly gilding the lily, in addition to that point, which is about the formula, there's also a point about the conditions which are required to be satisfied for the call option to be exercisable at all.
In a sense, that doesn't matter.
Well, in a sense, it doesn't. But they too depended on the health of the company's business and its profitability. So condition one was EBITDA of 1.3 million per annum in a particular year, and condition two was that any marketing facility that had been advanced by the defendant was repaid. And just for the call to note, that's 12.2a at page 33 of the supplemental bundle, and the definition of conditions in page 18 of the supplemental bundle. But the point is that what they say the company suffered as a result of the failure to comply with the contract meant that those conditions weren't satisfied. It also meant, as a matter of common sense, as my Lord Justice Newey pointed out to my own friend, that the defendant would be unlikely to want to exercise the option anyway. So the whole thesis that this option might have been exercised depends on the company not having been harmed in the way that it's alleged that it was because of the failure to comply with the contract. So it's clearly loss flowing from the actionable harm to the company in that sense. And then also, as my Lord Lewison just pointed out, of course, then when you get to the actual formula, the formula itself depends on EBITDA over relevant years. And so again, it depends on the profitability of the company. And it's quite striking that actually the formula under the call option isn't a million miles away from the process that the other side invite the court to adopt in its pleading in valuing the shares on a general market basis. Again, it's very much profit-based.
Just thinking around it for a moment, supposing that the company had brought the claim and suppose that it had made it out and got full compensation. In a general sense, subject to any inexactness in correlation, you would expect the value of the shares to have been restored. How does it work in terms of the clause 12 claim? I suppose you couldn't at that stage yourself afford to exercise a clause 12 claim to buy the shares at a nominal price on the basis that the EBITDA for the relevant years was very small. I haven't quite worked out how it plays out.
Well, it wouldn't have. The call option might not have become exercisable in any event, even if we'd wanted to.
No, that's true. Yes.
I mean, that presumably was the function of the condition, to
safeguard
circumstances which we could require the 50%. Well, if the main claim would succeeded, then of course it would swamp this alternative claim anyway. So this alternative claim would never arise.
But I mean, if the company had succeeded in its claim, so all the money's come into the company, the value of the shares is restored. Well, I mean, there couldn't then be any question of exercising the call option. Well, I suppose you might choose to exercise the call option and they then get no more than the value of the shares.
Indeed. I think maybe my Lord's point really is answered by the central point in Marex that I took the court to, that you don't have to look, and you mustn't look for any close correlation between the two. You don't have to establish for the reflective loss principle to apply that success by the company would replenish and therefore make good.
I mean, I follow that. At the same time, if you find that success by the company would have replenished, you might think that that was an indicator that the loss was reflected.
Well, it certainly would, yes. It certainly worked that way, but one doesn't have to go that far in order for it to be reflective. For obvious reasons, because it becomes extremely impractical to start. Indeed, one is going to have to end. If the rule did require complete correlation, what would actually happen is there would have to be trials all the time to try and work out whether there was complete correlation. And if you got to the point of complete correlation, then suddenly, bingo, the shareholders wouldn't have a claim, which would be obviously an absurd way to conduct to deal with these claims in any justice system.
And a field day for experts. And a field day for experts.
Well, indeed, indeed. Now, so the central point in relation to this alternative way in which it's put is that it is still a claim for diminution in share value. It is one that flows from the actionable harm that the company suffered, and as I say, the only difference is as to the precise method of quantification. And if I may deal just very quickly with the points in the appellant's skeleton on this, just to deal with those, their specific arguments. They say again that it's just, they just rely on the fact that it's a wrong committed to them personally which founds this claim. As I've submitted, that isn't sufficient to take it outside the reflective loss principle. Second, they say this is actually a claim for loss of their personal contractual entitlement, as they put it. But that's conflating such contractual rights as they had in relation to Clause 12, as to which they're actually non-existent really, but let's assume they've got some contractual right, is conflating that with the question of loss of value in their shares, because the contractual rights, such as they were that they had under Clause 12, have been unaffected by all of this. They haven't been taken away or prejudiced or varied in any way. All that's happened is, because of the company's unprofitability, which they allege to have been caused by the breach of contract, this option has not in fact become exercisable or been exercised in fact. That's exactly how they put it. Now, in fact, they, as the court suggested to my learned friend during his submissions on several occasions, they haven't actually got any contractual right, at least until the call option is exercised. Because even if the conditions for exercise of the call option are satisfied, it's entirely up to the defendant as to whether it wants to exercise its call option or not. So they haven't got actually any contractual right at all, unless and until the call option's exercised. Thirdly, the claimant said, well, sought to argue the company's got no cause of action in relation to this head of loss, because they point out, obviously correctly, that the company's got no contractual entitlement under Clause 12. Well, no, of course it hasn't. But it isn't about a breach of Clause 12. It's based on a breach of the implied obligations that are relied on, as my learned friend accepted under questioning from the court earlier. And the only relevance of Clause 12 is as to the alleged consequences of the breaches of the implied obligations that are relied on. And fourth, it was said by the claimants, well, look, the company and the shareholders have got to have the same loss. And this isn't the same loss. Well, we know from looking at relevant passages in Marex that actually, no, there doesn't have to be the same loss. The fact that the company has not suffered the loss that it's alleged the shareholders suffered through the lack of exercise of the call option is just irrelevant. And subject to any questions the court's got finally on this, if they were right on this, then that would present no reason for not striking out every other aspect of the claim, in particular the misrepresentation claim, because this is just one head of loss in relation to the breach of contract claim. And put very simply, one can see, having looked through the pleadings, of course, that the misrepresentation claim and the contract claims from a very different ground. Timing of the relevant events, obviously.
Well, essentially your point is that if you advance 3 claims, 2 of which are hopeless and one of which might be all right, you don't let the hopeless ones go to trial.
No, indeed. I shall say no more, but I respectfully endorse that.
And certainly not on the basis that you'll be there anyhow.
Indeed, absolutely. Now, that deals with the call option point. There's then the loss of initial investment claims, which I hope I can deal with fairly quickly. That's an alternative head of loss on the misrepresentation claim, and the court has seen how that's put at page 148 of the amended particulars of claim. The allegation in the amended particulars of claim is that the claimants, and I quote, have been unable to recover their investments in Motoriety. But for the first time, clearly, actually, in response to a question from my Lord Justice Newey, my learned friend accepted, yes, this is basically the subscription money for the original shareholdings of certain of the claimants. So, no mechanism for recovery of this the original subscription money is actually identified. But just a matter of principle, the shareholder's got no right to recover or to repayment of the subscription prices paid on the shares from the company or indeed anyone else. The shareholder might indirectly recover that subscription price if he sells the shares to a third party, if he persuades the company perhaps to repurchase them or redeem them, or if the company goes into a liquidation that is sufficiently solvent, in which case he'll get money back as a shareholder, which will perhaps be greater than the money he subscribed for the shares in the first place. He's not actually recovering that money, he's just getting money in respect of his shares. And of course, in all those situations, he can only do that if someone else agrees. So a third party agrees to buy his shares, or the other members agree to a members' voluntary liquidation, or whatever it may be. So in each case, he's not entitled to an exit route. And that's quite important, because what it shows is, essentially, this is just a means of trying to hide the fact that this is just another form of claim for diminution in share value. It's a very unambitious claim, because it's simply trying to claim the value of the shares as originally represented by the subscription money. So rather than saying, well, the shares are actually worth nil, and they would have been worth millions, if in fact there hadn't been a misrepresentation, all they're saying is, well, at the very least, we'd have got our original subscription money back indirectly in some way. But it's still a claim for diminution in share value. It's just put in a very unambitious, minimal sort of figure. So this is really all they're doing. They're just saying, well, here's an alternative, very minimal way of ascribing a value to our shares which has been lost as a result of the alleged misrepresentations. So the attempt to pretend this isn't a claim for diminution in share value just fails. Unless the court's got any questions about that, I don't propose to say any more about that particular head. Could I then deal with the argument from the appellants that this is unsuitable for strikeout, either because the law is uncertain or because the facts are uncertain? Can I just deal with those two propositions separately? The idea that the law is uncertain and the idea that the facts are uncertain. And as regards the law, the overview on this in our submission is that there isn't any relevant uncertainty in the law in this area at all, quite the opposite. Post-Marix, we have the Supreme Court, a seven person Supreme Court, identifying very clearly what the principles are. And on the basis of those principles, we have a paradigm case of reflected loss pleaded. And it's a paradigm case for a strikeout as well, we would argue, because if that is decided, if my submissions are accepted now, and it is accepted that therefore this claim is hopeless, a vast amount of cost will be saved, a huge amount of court time will be saved, and a lot of delay will be saved. And this matters because, as the court will have seen, serious allegations are made. So if this matter goes to trial, then a large number of witnesses are going to have to deal with this hanging over their heads for a long period of time. And if this claim is hopeless, then that is another good reason why it should be struck out now. Now, we of course accept the general principle that if you have got a genuinely uncertain and developing area of law, then that is generally, normally, a good reason for thinking carefully about whether to strike out rather than allow the matter to go to trial. But that simply isn't the case here. The claimant sought to say that post-Marix the law is in a state of transition, but it simply isn't. The law has been defined very clearly. And it's important to note, of course, that what Marix did was actually to cut back the scope of the law. This isn't a situation where the Supreme Court has sort of opened the floodgates, as it were, and allowed the possibility of the law developing. On the contrary, it's cut it back. So more than ever, we know very clearly where we are. And it isn't enough to point to some particular issue at the margins of this principle, where there may still be uncertainty. That's really all that's been done, as I'll show in a moment. Such marginal questions can be perfectly well resolved on a strikeout application. But more importantly, none of those marginal questions that my learned friend points to the extent they are still extant now, have got anything to do with the issues in this case. And so any submission that the law is in an uncertain and developing state has to be focused on the actual issues in front of the court. And very plainly, there is no such uncertainty identified by the appellants. They identify in their skeleton 4 points where there's supposed uncertainty, which causes a difficulty, they say. Now, none actually assist, because to the extent they do involve any uncertainty, none of them has got anything to do with the matter before the court. Paragraphs 1 and 2, they're essentially the timing point that arose from Lord Justice Flo's decision in Nectarus, which my own friend accepted post-Primeo and post this court's decision in Allianz, has been resolved. So that's disappeared. Then paragraph, the second point they make is they say, well, it's not clear whether the reflected loss principle applies to claims for specific performance. With all due respect to my own friend, so what? It just doesn't matter. It's nothing to do with this case. This case is a claim for damages. So it doesn't matter. And fourthly, they say, well, we, the defendant, formally reserve our position to argue, if this were to go any further, about who bears the burden of proof on this. Well, that can't help him, because all we're saying is, well, if this were to go further, we might take this point. That can't improve his position now, at this level, where we can't take the point. We bear the burden. We accept that. So again, that's not an uncertainty that's of any relevance. There is no legal uncertainty of any relevance at all.
Well, there is no burden of proof. Is there in a strikeout case? You assume that he's going to prove what he says he's going to prove.
Well, I think, yes, indeed, but I think on that assumption, the question is, do I have to bear the burden of persuasion, effectively, to persuade the court?
Well, that's different. That's a question of the law.
Well, indeed, yes.
But
indeed.
in terms of burden of proof, strictly so-called, there is none. You assume that he's going to prove what he's pleaded.
My Lord's right. I apologise. That was, yeah.
It harks back to a sentence in Shaker and Badrawi, doesn't it?
Indeed, it does. Exactly. And that's why we reserve the position, but no more than that. So that's the uncertain law point. There's nothing in it. Uncertain facts. Well, it's suggested that this application raises fact-sensitive issues, so a trial is necessary. Well, first, by way of response, we are, as has been clear throughout this hearing, accepting that the court must assume that all the pleaded facts are proved. But this is done on the basis of the allegations of fact made by the claimants. And the claimants haven't been able to identify any question of fact which might have to be resolved at trial that might make any difference to the issues before this court. The only one that perhaps has been alluded to is this idea that, oh, well, it might be necessary to work out the extent to which the loss suffered by the company is the same as the loss suffered by the claimants. But as I've shown, that isn't actually relevant at all to the application of the reflective loss principle. So that's not actually a point that arises. Again, can we just look, I'll just very quickly deal with the points they do make in their skeleton argument. This is paragraph 6.3.2, which we don't need to turn it up. But they identify three contextual questions, as they put it, that they say are relevant to the reflective loss principle. But none is actually relevant or meaningful. I mean, the first, they say, the question is whether the claimant's loss was, quote, the result of a loss suffered by the company in consequence of a wrong done to it by the defendant. But that's just to state the reflective loss principle or an aspect of it. That's not a factual question. And the same really applies in relation to their second point. They say there's a question as to whether the loss alleged is, quote, separate and distinct from that suffered by the company and caused by breach of a duty independently owed to the shareholder. Well, again, that's just setting out an aspect of the reflective loss question. It's not identifying a point of fact. And as I've submitted on the basis of their own pleading, the answer to that question is clear and it's against them. The reflective loss principle applies. And then the third point they make, that really splits down into two. They say there's a question as to what capacity the claimants were acting in negotiations with the defendant. But we've gone through the particulars of claim. We can see that is pleading. They're acting, the first two claimants are acting both on their own behalf and on behalf of the company. And then it's also said, well, there's a question as to in what capacity did the claimants suffer loss? But their own pleaded cases, they suffered diminution in share value. So they clearly suffered that loss in their capacity as shareholders. There can't be any other capacity in which you can suffer diminution in share value loss. And tellingly, they don't explain anywhere in their skeleton, in relation to those supposed questions, what they contend the position should be in fact, and why, if it were found in that way at trial, it would make any difference to the application of the reflective loss principle. So there's really nothing in this point at all, and I emphasise again the point I made earlier in passing, that they have had every opportunity to plead any fact that they thought might be relevant to the reflective loss principle, both by way of amendment, you've seen their draft amendment, and also in their reply. And there's nothing there. So, my lords and my lady, unless I can assist further, those are my submissions in relation to reflective loss. So if I could turn then to the settlement agreement point.
Yeah.
Obviously a very subsidiary point, doesn't arise at all if we're right on reflective loss. On that basis the whole thing would be struck out. This is a much narrower point. It only goes to the claims by the second claimant, and indeed only some of those. As the court heard from a learned friend, it's the services representation claim and then all the breach of contract claims in relation to the second claim. It's actually quite a narrow point as a matter of construction. Before turning to the words, can I just deal with my learned friend's opening point on this, what he called, I think, a context point. He said, oh, it would be terribly surprising if, in fact, the second claimant had given up for just £60,000 enormously valuable claims of diminution in share value. Well, no, it wouldn't, because what he did was he carved out what he thought he had from the settlement. And the question is whether actually he carved out successfully or not. It's a matter of, because this is all about the scope of, an exclusion from, an absolutely general universal settlement of claims. So the context point goes nowhere. Now, if we can look at the words, my lords and my lady have looked at them. Supplementary bundle, tab 5, page 117. As I say, it's very important that this is about the scope of an exclusion from a general settlement of all claims. The general settlement is absolutely plain. To quote the words used, what is settled is all and any other claims which the claimant, that's the second claimant, has or may have against the respondents, that includes the defendant, whether arising out of employment or not. So it's an absolutely blanket settlement, subject to the exclusions. And there are 4 specific exclusions. We, of course, are concerned with the last one, which is any High Court claim in relation to the claims specifically referenced in the steward's letter. Now, the first point I want to make is that the claims which we say fall outside that exclusion and therefore have been settled, that is the services representation claim and the breach of contract claims, are not specifically referenced in that letter of claim from stewards because they're not mentioned. Several claims are mentioned, misrepresentation claims, but not those. The most that Malone and Friend could say is, well, some of the facts that now form the basis for those claims which we say have been settled were referred to in that letter of claim. But we say that's not good enough because that doesn't make the claims specifically referenced. And we say that does require, as a matter of the plain and natural meaning of the words, that the claims be expressly identified as claims. We say it's clear that that's what the words are intended objectively to do, because first, the claims have to be referenced. That clearly means actually identified rather than just alluded to in some way. They have to be referenced. That means referred to. Actually identified. And second, they have to be specifically referenced. And that must require some degree of specificity rather than just generality. So we say it's clear they haven't been specifically referenced. That's the natural meaning of the words in context. And part of that context, of course, is that this is an exclusion from a general settlement. So what you'd expect is that the parties, all sides, would be wanting to try to achieve some clarity rather than ambiguity. And any other construction of the words specifically referenced would, in my submission, lead to exactly that, ambiguity. Because if you don't have to specifically identify a claim, but merely, for example, refer to facts which might give rise to a claim, you're inevitably going to run into argument as to whether, in fact, a particular claim has been sufficiently evidenced in the letter by reference to merely facts underlying it. Whereas if you have actually identified the claim, breach of contract, this is the contract, this is the breach, then you have, in my submission first, specifically referenced it, and that means it's absolutely clear that it's in and not out. So clarity and certainty are very important here. My lords, my lady, in that context, the reservation of rights that my lady friend relies on in the letter can't assist at all. It cannot be suggested that just because the letter said, oh, well, we reserve the right to make further claims, that means that absolutely anything that eventually found its way into proceedings pursuant to that letter of claim was somehow specifically referenced in the letter. I mean, that would drive a cage of horses through the obvious intention of this, which is to achieve clarity as to what has been settled and what hasn't.
Well, in a way, it might be said, I suppose, that the specifically referenced is due to remove that reservation of the right to plead other claims. Because the pre-action protocol letter preceded the settlement agreement by
yes, indeed.
a few months.
Yeah, indeed.
One possibility is that in order to remove that reservation of rights, they say, well, only the ones that are specifically referenced are excluded.
Yes, that would certainly be its effect. Yes, absolutely. And thereby that would achieve clarity. And my learned friend suggested, well, all that was missing was the punchline, as he put it, in relation to the claims that we say have been settled. Well, that's not the case at all, because take the breach of contract claims that are now asserted. It's not just a lack of reference to there being a claim in breach of contract. There isn't a reference to the contract and the obligations, the implied obligations relied on at all. So it's not just the punchline that's missing, the whole shooting match is missing. So that's the first point, they're not specifically referenced. Now, the second point, building on that, really is to ask, well, what does the rest of the relevant wording of that clause 4 mean? And these are the words, any High Court claim in relation to the claims specifically referenced. These are certainly the words that Maloney Friend put considerable weight on in the first instance, and as I understand it, does again. Now, just as a preliminary point, I'm not sure how much turns on this, but here, in our submission, the word claim is being used in two different senses in that phrase. As is often the case nowadays, a claim can refer to the proceedings, and a claim can also refer to the cause of action and the remedy sought. Now, claim in High Court claim, I think, must mean, in our submission, the proceedings, High Court proceedings. Whereas clearly, specifically, so claims specifically referenced in the letter, that must mean cause of action. That's just the common sense, natural meaning of those words used in that context.
And so you say meaning is equivalent to any High Court claim in respect of the claims specifically referenced.
Absolutely, yes. The point is that what's allowed is a set of High Court proceedings that makes the claims specifically referenced in the letter. And what I understand my learned friend to be arguing in relation to the words in relation to is that, well, he says, well, these are words of connection, as he puts it. And so he says that even if you've got a cause of action that isn't specifically referenced in the letter, you can bring it in High Court proceedings if it's in relation to those causes of action that are specifically referenced in the letter. And that just introduces all the ambiguity which quite clearly the parties must have been striving to avoid, because it opens up a very difficult question as to, okay, when is a cause of action that might be included in some High Court proceedings in relation to a cause of action that has been specifically spelled out in the letter of claim?
I mean, one might wonder why you would bother to require claims to be specifically referenced if, at the end of the day, all you required was some connection of a relatively vague kind.
Well, precisely because it's specifically referenced, as I've submitted, makes it very clear that what the parties are wanting is some sort of express identification of a claim. And if that's right, then the meaning that Malone and Friend attribute to the words in relation to would just destroy what had been achieved by using those words specifically referenced. I mean, that's with any contract. Of course, with hindsight, you can improve the words, make them clearer. But in our submission, the natural meaning in this context is that claims have got to be actually expressly identified in the letter, and then they can be brought in High Court proceedings. And the reference to the High Court is, it would seem, is because, of course, what is primarily being settled in this clause is employment tribunal claims. And so one suspects that's why the parties use the High Court claim, High Court proceedings, because that's obviously what was contemplated by the letter of claim, and that's in distinction to what is very plainly being settled, which is anything arising out of the employment relationship, which will give rise to an employment tribunal claim. So that's why we say essentially that the judge was entirely right on this settlement agreement point. to the extent it arises. I don't like an assist record any more on that.
No, thank you very much,
I
Mr.
think I've
Thompson.
dealt with all the points in. Thank you.
Now, Mr. Old, how long do you need for a reply?
I'm not entirely sure. I was going to ask if I could do it tomorrow morning.
Well, it depends how long you're going to be.
I would have thought half an hour, 3/4 of an hour.
Oh, as long as that.
Yeah.
All right. Sit again tomorrow at 10:30.
Thank you.